Act of Settlements, 1701. Let's just begin with Wikipedia. It states the Act of Settlement is an act of the Parliament of England that settled the succession to the English and Irish crowns to only Protestants, which passed in 1701. More specifically, anyone who became a Roman Catholic or who married one became disqualified to inherit the throne. Let's go to the government website to see if we can see what they are going to continue with and see if they say anything different. 1701 Act of Settlement. The Act of Settlement was passed in 1701, reinforcing the Bill of Rights agreed by William and Mary in 1689. The main aim of this legislation was to ensure a Protestant succession to the English throne. Okay, now as we see here, these are government regulated systems to which they're going to speak predominantly to the issues of rules of succession. Well, we're not interested in the rules of succession, really, excuse me, because those are matters of government and how they need to act accordingly. What we're interested in is as we move further down, and I think this is 6 or 7 within the Act of Settlement 1701. I'm not going to take any time here to count because they're not which numbers they are. So I'll just start reading. It states here that no person who has an office or place of profit under the king or receive a pension from the crown shall be capable of serving as a member of the House and Commons. What that means is that those ministers that are paid immediately from the crown or made immediately from the king are the titles that we are most interested in, because those are the ones that then protect the English common law, okay, and protect the rights for us to affect the monarchy as fideicommissium. So if we want to deal with the legal title and vest that through, as we're going to learn later on, the Settled Land Act, then it is those accounts that are paid through the king that we must seek the attention of. So I found this out myself. I did a petition um, that was bringing in the Attorney General through an issue to speak to the Settled Land Act 1925 and, of course, to vest my legal title. And what I got a response from was from the Legal Services Branch and the Deputy Minister's Office, thereby bringing out the acknowledgement that I must have did something wrong in my paperwork in order to command the attention of those institutions that belong to government. As soon as your notice right there. If you are sending a document to a minister that you know is paid directly from the king, and you somehow get the interest of and the scrutiny of the government, means that you've said something wrong. Okay? Don't look to blame immediately. Just look at your paperwork first and how it may be set up that somehow you're bringing to light some interest of commingling that now the minister says, I can't deal with it because, he's commingled two things here, and now I've got to, by default, send it over to the government, and now the government's responding. Okay? That's your first notice that you're doing something wrong if you're commanding any interest on the government whatsoever. And that's the U.S. government, whatever. It doesn't matter because, again, your birthright, as we've already discussed in the Act of Settlements, 1700, is the English law. That's before those interests that are territorial rights granted to governments. Okay. The second point of interest that we want to bring our attention to reads that after the said limitation shall take effect as aforesaid, judges' commissions be made and their salaries ascertained and established, but upon the address of both houses of Parliament, it may be lawful to remove them. I know it doesn't read to the untrained mind uh, any more than, the Parliament can interfere with the court, the right to remove them if they don't act accordingly or behave accordingly to said laws. But what it did at this point was put in the hands of the judicial system their own right to establish and ascertain their salaries, which means they at that point established judicial independence, not paid by the monarchy and the crown directly, and they're not paid by the government. Therefore, they cannot be influenced by either. That's very important. So if we're affecting the courts correctly, then we know that they have the judicial independence to deal with that interest and that subject matter that we want to be made known, which is that legal title held in common law, and predominantly filtered through the capacity of fideicommissium of the monarchy, who holds the right of the law. That's all it is. That's what the title represents, is the entirety of the settlement of the common law, to which when we want to go to court, we only speak to that one interest, and they have the judicial independence not to be influenced by the monarchy or the crown, because they're not getting paid directly. So that's what we want to draw our attention to, is that judicial independence. Now I want to go back into the Act of 1701, because it's important to have this assimilated and to really drive home how they write things in order of how they are seen by, well, they like to use the idea of not rules of action, rule of law. Okay, they use that word, but they can never define it. Well, here it is defined in succession and how they write it. So I'm going to read it. This is again the Act of Settlement 1700, and it's section 4, and the headline of this is the laws and statutes of the realm confirmed. Okay, and here it is. Here's your warranty. Okay, and whereas the laws of England are the birthright of the people thereof, and all the kings and queens who shall ascend the throne of this realm ought to administer the government of the same according to the said laws, and all their officers and ministers ought to serve them respectively according to the same. The said Lord, spiritual, temporal, and commons do therefore further humbly pray that all the laws and statutes of this realm for securing the established religion and the rights and liberties of the people thereof, and all other laws and statutes of the same now in force, may be ratified and confirmed, and the same are by his Majesty, by and with the advice and consent of the said Lord spiritual and temporal and commons, and by authority of the same ratified and confirmed accordingly. There it is, the rule of law. First, when you are born, you have the birthright. At that moment, it's instilled the birthright of you as an individual, which is under the address of the class of people, to which then the kings and queens shall ascend, holding that right, okay, in your interest, to which then the government then comes in there under, who subordinate to those rights under the kings and queens, as the ministers who have the duty to perform those actions that are granted to them by the kings and queens. To thereby we move into the Lord's spiritual temporal commons do humbly pray. Pray to what? To those laws. That's the God. I mentioned that, I think, in video 1. That's the God they prayed to. Okay, it's not some hierarchy system or man figure that sits up in the clouds and judges everything. The judges the laws that man has agreed to, first through natural and then those common laws, but those rules of successional interest. So they prayed to that everybody would hold those laws, to then arrive to the consent of the Lord spiritual temporal and commons, who are then instilled the constitutional monarchy, which was established through the Bill of Rights of 1688. Okay? Hopefully I didn't make that too convoluted, but the importance of how they write things, even how William Blackstone writes things. They don't mix words. They create things succession purposely so that you can see how the rule of law is established and where you begin, and the titles begin, and those territorial rights and proprietorships begin. Each one is segregated proportionately to those interests, and nor can it commingle. So when we get upset the government is overreaching my right, my absolute right, they're not, because they have no right in the interests of your absolute right, nor to those interests in common law. What is happening is the assumed presumed agreement that you are obligated to perform, and they're seeing some sort of commingling that, hey, you're holding some interest in their under the territorial right, or you are saying something that addresses something under government, and so they throw your ass back into equity, and now they administrated that interest under their rules, to which then the court comes in and then says, well, I'm obligated to judicial independence, but I'm obligated to judicial independence to follow those laws under legislation. And then there's those laws that are established under the common law. When you bring that in, they'll follow that. Okay? So, with that, I think I'm going to speak to what is a point of interest. There's the Scottish Claim of Right, 1689. Only for a point of interest to show you that, how everything's secured. And even though it says Scottish Claim of Right, is it an act of English law? Then, hey, it's your birthright. So you can use it if you want to. Okay? And I've found some information in New Zealand. Okay? And speaking about not judicial independence, jurisdictional independence, and jurisdictional power. And I'm going to bring to light to some of that too. Okay, with that, we'll close this session.